Hello, my name is R.More, and I'm using this opportunity tonight. I'm a longtime resident of the city of Chicago in the state of Illinois to address the problem of what we're referring to as the Haldol Menace. And I'll briefly explain the background of this problem, and then I'll explain what happened to me in regard to this, and then I'm going to address some implications of the problem. I'm going to offer some proposed solutions, as I'm very concerned that the members of the audience that might be viewing this could be subjected to this same horrendous abuse of the psychotropic drugs and of the psychiatric field and of in various penal institutions or in mental institutions or in different settings, even hospital emergency rooms, where someone might be subjected to a involuntary administration of the psychotropic drug Haldol. On the 25th of November of 2008, Robert J. Moore, a misdemeanor defendant charged with criminal trespass to state-supported land for refusing to leave courtroom number 248 of the Richard Daley Center of the Circuit Court of Cook County, Illinois, on the 13th of June of 2008, who had been ordered to undergo a behavioral clinic exam, a BCX, at the Cook County, Illinois Forensic Clinic, but who had refused to undergo any such type examination unless and except RJM, myself, would be permitted to audio tape any exam that would have been conducted, due to the fact that in previous criminal prosecution in which Robert J. Moore was eventually acquitted on a directed verdict, Robert J. Moore had been subjected to multiple such type exams and had been alternatively declared fit and then unfit for trial based on the same answers to the same questions. At any rate, Mr. Moore was taken into the custody of the Cook County Jail on the 25th of November of 2008 for allegedly having violated a condition of his bond, notwithstanding that the Cook County judges issuing orders requiring behavioral clinic exams are obliged to inform defendants ordered thereto that an examinee may refuse to answer any questions at any such type exam that would ever be conducted. Evidently, due to myself, Robert J. Moore's demanding upon his arrival at the jail a blood test and a full medical examination in order to ensure that should Robert J. Moore contract any of the types of diseases and or maladies from his period of detention in the Cook County Jail, which were described in the letter from the Office of the United States Attorney for the Northern District of Illinois to the President of the Board of the Commissioners of Cook County and the Cook County Sheriff on the 11th of July of 2008, and or demands which Robert J. Moore made to be provided a writing utensil and a piece of paper in order to compose a petition for the issuance of a writ of habeas corpus pursuant to the provisions of 28 U.S.C. 2241, RJM was assigned to the psychiatric ward of the jail, the Cook County Jail, which is known as CIRMAC. While being detained in such entity, Robert J. Moore was subjected to the forcible injection of the psychotropic drug known as Haldol on 3 occasions, before RJM finally succeeded, after numerous phone calls to relatives and affiliates, in procuring the assistance of a Dr. Linda Shelton to get Robert J. Moore bonded out of the jail. Robert J. Moore was released from the Cook County Jail in the wee hours of the 28th of November of 2008. Robert J. Moore's purpose in composing and transmitting this abbreviated chronicling of the events and developments described herein, which is now being transmitted via the audio video on YouTube to try to access a larger audience of potential future victims of this abuse, in transmitting this, is to provide an abbreviated chronicling of the events and developments described herein, so as to alert as many persons as might be alerted by the reception and reading of this document, the viewing of this video, of the peril in which everyone, but especially political dissidents, advocates of unpopular causes, and those unwilling to make concessions, which in a given instance it would evidently appear that it would be justified to not make concessions, that in a given instance it would evidently appear to they would be justified to be made. Any given illicit or otherwise unjustified order, in terms of complying with an illicit or unjustified order, command or demand, or any non-capitulators in general, remain so long as psychotropic drugs, and Haldol in particular, can be forcibly administered to detainees of whatever type in situations in which there would not be present any imminent threat to the life and or physical integrity of anyone in incarceration and or other type of detention settings. That's the purpose of this. That might be somewhat of a long sentence, but it is objectively diagrammable. It is not unintelligible. It's merely written in a sophisticated form so as not to neglect to do justice to the comparative complexity of the matters that's involved. It's addressed so that judges cannot find holes in this position. I'm endeavoring to contribute to the construction of a wall that's going to protect the aforementioned individuals from having Haldol involuntarily administered to them for unjustified purposes. Haldol has been proven to cause eye and brain damage and death in some instances. It is imperative for the safety of all citizens of these United States of America that those responsible for the involuntary administration of Haldol and similar psychotropics be criminally prosecuted, sued civilly, removed from positions in which those responsible for unjustified involuntary administrations have participated in the perpetration thereof, and subjected to the confiscations of license and or certifications which would have been the instruments of a given individual's participation in the given perpetration of a given such administration, so that none of such administrations or none of such administrators and or accomplices in any administration thereof would succeed in getting away with the participation in any such type administration with impunity. In a nutshell, what I'm saying is that I'm reaching out to members of this audience and asking, what can I offer? How can I help? How can the Institute of St. Michael the Archangel help to protect you from having you or a loved one have Haldol or such similar other mental straitjacket type psychotropic drugs administered to you on an involuntary basis? What can we do to assist you? We've identified the problem. We have a number of individuals in this room who've been subjected to this same appallingly abusive treatment, which is, again, life-threatening. It causes brain damage, it causes eye damage. When a person is injected with Haldol, I was subject to dystonic reactions on the Friday the 29th of November, which were truly dreadful. The incapacity, tardive dyskinesia, some of the symptoms of which are the incapacity to keep one's tongue in one's mouth, the incapacity to control one's saliva, the incapacity to breathe, function, to think clearly. This is a very serious matter, and we're going to offer some proposed solutions. And one of the solutions is to present evidence to a special grand jury under 18 U.S.C. 3332A, and when the U.S. Attorney for your particular district then neglects or refuses to present that evidence to a special grand jury, you then have to file what's called a petition for the issuance of a writ of mandamus to the district court judge in your local jurisdictional area in which a person would have had Haldol involuntary administered, because that is generally a violation of 18 U.S.C. 242. In many cases, it's also a state misdemeanor of medical battery. So there's no point in leaving the people who are responsible for this to in any way be able to participate in these perpetrations with impunity. And my purpose here today on this video is to try to help put enough structure, sufficient structure around this problem so that we can price the abuse of the use of this psychotrop. Continuing with, we've now identified the problem of the involuntary administration of psychotropic drugs to persons who are not a threat to self or others, who have not actually participated in anything that can justifiably be construed to constitute bizarre behavior, to seek a writing utensil and a piece of paper in order to file a federal habeas corpus. There is no situation in which a person could ever be detained in which it will be justified to prioritize the rule, protocol, regulation, practice of some entity on some city block anywhere in America that would take precedence over federal law. In this particular case, I was a pretrial detainee, or if a person was a post-conviction detainee, then his remedy would be under 18 U.S.C. 2254, 2255. But in my particular case, the federal habeas corpus applied as a pretrial detainee under 18 U.S.C. 2241. There is no situation, again, in which that remedy is not available to anyone who has been accused of a crime from the time he or she is taken into custody. Habeas corpus is applicable, and whatever the governing entity is which is responsible for the detention of a given detainee, that entity is subject to criminal and tort liability for neglecting or failing or for otherwise not providing the means to file a federal habeas corpus, so that a federal judge can make an adjudication as to whether or not the detention of a given individual in a given configuration of circumstances is compatible or incompatible with the protections guaranteed to all citizens of this country according to the Bill of Rights of the United States Constitution. So, getting back to what are some of the remedies then which can be used, accessing the grand jury, and then when your prosecutor for your particular federal jurisdictional area refuses to present that to a grand jury, to file a petition for mandamus. If the mandamus is not granted at the district court level, to then take it on. To then file an appeal of that, and if that is not granted, take it to the Supreme Court of the United States. One can also go directly to the United States Supreme Court on what's called the Supreme Court Rule 20 petition for the issuance of a special order. That's Rule 20, the United States Supreme Court rules, so that one can circumvent a lot of the bureaucratic paper shuffling to try to get the remedy sooner rather than later, because this, again, is deadly, okay?